Good morning and welcome to our webinar titled Best IP Practices for Technology Transfer in China. This webinar is co-organized by the China IPR SME Helpdesk, the Flanders China Chamber of Commerce, and the EU-China Business Association. My name is Peter Siegel. I work with the China IPR SME Helpdesk, and I will be your moderator for today. And before we dwell deeper into the subject matter, I would just like to introduce the platform we are using, the GoToWebinar. I'm not sure if many of you in the audience are familiar with it. The important thing is that this tab enables you to raise your hand and to write us questions anytime during the webinar, which will be answered during the Q&A session in the end. I would like to introduce you very briefly our initiative, the China IPR SME Helpdesk. We are an EU-funded project, and we provide free services to EU SMEs who wish to expand and conduct business into China. We specifically deal with intellectual property-related issues, and we have an inquiry helpline where EU SMEs are welcome to ask us any questions, intellectual property-related questions, that they encounter while doing business in China, which they will receive a confidential reply from our legal experts within 3 working days. We also frequently organize workshops and webinars like this one on IP-related questions. And we have our own website and blog where we publish IP-related material, legal materials, podcasts, recordings of these webinars, business guides, fact sheets, etc., etc. And without further ado, I would like to introduce our 2 speakers for today. Firstly, Ms. Gwen Song, the Executive Director of the Flanders China Chamber of Commerce and the EU-China Business Association, and Matias Zubimendi, our very own IP Business Advisor at the China IPR SME Helpdesk. So after this brief introduction to the webinar and the topic of the webinar, we will listen to the presentation of Ms. Gwen Song about the Flanders China Chamber of Commerce. And then Mr. Zubimendi will give us an insight into the best IP practices for technology transfer in China. The webinar will conclude with a Q&A session, where, as I already mentioned, you are welcome to write any questions that you might have in the questions section of the webinar panel. And then without further ado, I would like to give the floor to Ms. Gwen Song. Gwen, I believe that the participants are able to hear you.
Thank you, Peter. Ladies and gentlemen, good morning. On behalf of the EU-China Business Association, the Flanders China Chamber of Commerce, I would also like to warmly welcome you to our 3rd joint webinar with the China IPR Helpdesk. As a chamber, we attach a lot of importance on IP, and we think that companies doing business with China are wise to have an IP strategy included in their China business plan. Today, we are experiencing difficult times, but China is recovering from COVID-19 and things are almost back to normal in China. Economists now believe that after the 6.8% decline in Q1, Chinese growth could be positive in the 2nd quarter, signaling a successful recovery. And during a recent survey of European companies in China, European companies stated that they remain committed to the Chinese market and that it remains their top 3 destination for investment. Furthermore, also a majority of European companies said that Chinese firms were equally or even more innovative than European firms, and they rather see an opportunity in an increasingly innovative China rather than a threat. China has already become a leader in innovation in several areas, such as the internet industry and artificial intelligence. China became the world leader in international patent filings in 2019, with 60,000 applications overtaking the US. And for the 3rd consecutive year, China-based telecoms giant Huawei Technologies topped the global ranking in 2019 with 4,400 PCT applications. European businesses feel China field, China compares favorably to other countries as far as government incentives, low R&D costs, and R&D teams' productivity. However, in other areas such as internet access and intellectual property rights protection, China still has a way to go. The EU and China will be having the next round of negotiations on the EU-China Investment Agreement, and this will offer an opportunity to increase trade and investment. It will offer new and better market access for investors in Europe and in China. The aim was to sign this agreement in 2020, and we hope that is still the case, taking into account also COVID-19. For the full year of 2019, the value of completed European FDI transactions in China reached $12 billion, which is up more than 70% compared to $8 billion in 2018. And the top industries were automotive, agriculture, food and consumer products and services. For 2020, automotive and financial services are picking up as China lifts equity cap requirements in these sectors. Let me mention a few words about the EU-China Business Association's role and activities. The EU-China Business Association is the association of bilateral China business associations in the EU, aiming at promoting the economic and trade relations between the EU and China. Today, we have 19 member associations and represent more than 20,000 European and Chinese companies. The aim is to be complementary to the national level so that the member companies can work on a larger scale and can deepen their cooperation with Chinese business partners. The Flanders China Chamber of Commerce is a member of the EU-China Business Association and supports companies doing business with China. Our chamber was founded by the largest investors from Belgium and China, such as Ageas, Bekaert, Barco, Picanol, Umicore, and so on. Our aim is to help Belgian companies expand in China and to assist Chinese companies to set up in Belgium. We provide a weekly China business newsletter to keep you up to date on China's economy and trade. We actually monthly organize a few webinars on how to and how not to do business in China, and we also give expert advice. Normally, we also receive many Chinese delegations and organize business matching meetings that we can introduce to you. But yeah, due to COVID-19, this is not happening. But in the meanwhile, there are a lot of online cloud exhibitions in which we work together with Chinese partners and that you can also do online negotiations. So we are at your disposal for any further information, and we also welcome you for a talk on how we can further assist you with your business with China. Thank you.
Thank you very much, Gwen. And now I would like to give the floor to Mr. Zubimendi. And before we start the presentation on technology transfer, I would like to invite you to a very brief warm-up exercise. If you click on the poll section of the panel, which I believe that you will be able to see very soon. Yes, it's open. I would like to ask you whether your enterprise conducts technology transfer activities on China. Either yes, no, or no, what you plan to. I will give you a minute and a half to answer the poll. And I'm sure that Mr. Zubimendi will be able to reflect on the answers that you provide in his presentation. Okay, the poll will be closed in 10 seconds. Currently, 25% of the participants voted yes, 30 voted no, and 45 voted no, but we plan to. Okay, the poll is closed. I believe, judging from the responses received, almost half of the participants voted no, but we plan to. This will be a very useful presentation for all of those enterprises that wish to conduct technology transfer in China. And I would like to very briefly introduce our speaker, Mr. Matias Zubimendi, who is, as I mentioned, the IP business advisor at the China IPR SME Helpdesk. Mr. Zubimendi has a master's degree in Chinese civil and commercial law from Peking University, as well as an intellectual property role from Austral University. Before joining the IPR SME Helpdesk, Mr. Zubimendi worked for various law firms and also worked as an assistant professor in various China-related and intellectual property-related fields in China and also in Europe. So I would like to give the floor now to Mr. Zubimendi, and Matias, the floor is yours, and you have control over the slides.
Perfect. Thank you very much, Peter. Let me see. Can you see now my presentation?
Yes,
Peter?
we can.
Okay, great. Let me go. Okay, thank you, Peter. Welcome, everyone. Today we're going to talk about technology transfer to China, how to perform, and we're going to take a look at what precautions SMEs have to take into consideration before deciding to do technology transfer to China. On the screen, you can see the structure of my presentation. First, I will do an introduction of intellectual property rights for those who do not have good knowledge about the topic. Later, I will introduce the technology transfer itself. And then basically we will analyze some rules, what we have to do in terms of bureaucracy, how to study your Chinese counterpart, what are and how to protect trade secrets. We will talk also a little bit about the company types and the rules about technology transfer for them. And finally, we will analyze some of the main contracts that you should take into consideration and some specific clauses about those contracts. But first, let me introduce a little bit about what intellectual property rights. When we talk about intellectual property rights, we talk about innovation patents, utility models, design patents, trademark, copyrights. When we talk about innovation patents, what we are talking about is the protection of the functional use of a product, but also we're talking about processes. The most common ones are manufacturing processes. In China, we have innovation patents and utility models that are called small patents. The requirements are the same, but the government is less severe when analyzing if they were fulfilled or not. When we talk about requirements, we are talking about three. The first one is novelty. The technology has to be new. This means that it shouldn't be known by anyone in the entire world. This is a global novelty. This means that the technology cannot be disclosed or published. The second requirement is a non-obviousness. This means that when we are analyzing if a technology can be patented or not, we have to analyze what is the current state of art and if the new technology is one step further from that. And it really means that a scientist expert on the field checking the state of art, if that person cannot foresee or it's not obvious for that person the new technology, then there is this non-obviousness requirement is fulfilled. The last one is the industrial application. This means that the product or the process has to be or can be applied to an industrial process. Design patents are also patents. The procedure is very similar. However, what they protect is the aesthetic aspects of the product, is how it looks, the appearance of the product. It also requires novelty, that it has to be global, and there is a very important difference that I would like to highlight between design patents in the EU and China. While in the EU, design patents that are not, or those designs that are not registered yet as design patents, they do have certain protection, and there is a grace period for registering them. However, in China, this is not the case. So any design that was disclosed, it would be impossible to register with the design patent. With trademarks, we are talking about any sign that identify product and services in a certain market. The most important part of the trademark is that it has distinctiveness. This is that it cannot be confused with any other registered trademark. And you can register as a trademark almost everything, because it's every sign that can help your product to be recognized. So it can be names like your company name, but also the name of the product. It could be pictures, logo. It can be in 2D, 3D, almost anything. When we talk about copyright, we are talking about the protection of how a person expressed an idea. It's not the idea itself, but how it was expressed. It should have originality. This means that it should come from the mind, from the heart of the artist. But even though copyright is normally associated, of course, with art and paints, draw, writing, for SMEs, it's also important because in China, software, it is protected with copyright. And for example, the databases are protected also with copyright. When we talk about trade secrets, even though we will speak about trade secrets with more detail later in the presentation, I would like to just introduce it's any information that is secret, it has value for being secret, and is being protected. These are also the three requirements: value, secret, and protective measures. In the case of trade secrets, they are not registered. Since they are a secret, they cannot be disclosed to anyone, not even the registration agencies. So the protection will stand as long as the trade secret remains exactly as a secret. That's why it's kind of risky, because companies can lose protection in any minute. It's just a matter of a mistake, and the protection is lost. In the case of know-how, because for technology transfer, companies will exchange some certain level of know-how. When we talk about know-how, we are talking about practical knowledge on how to accomplish something. Normally, a product can be protected with a patent, but how to produce a product, what are the secret, how to manufacture it, it involves central level of know-how. There is some expertise on the people who are producing it, that it also has value. And how can we protect that? Well, the mechanism is going to be very similar to trade secrets. We could also even say that know-how, it is one of the possible trade secrets. But we will talk about this later during the presentation. Finally, what are the main principles of intellectual property rights? There are two main principles. The first one is registrations. And in China, this is very important because there is a a very basic rule that is called the first to file. This means that the first person or company to file the registration of any of these intellectual properties that I mentioned, except trade secrets because they are not registered, the first person or company applying for the registration will have a priority over any other person or company. But in the case of China, it's also a fact that it is, for the moment, very difficult to take down a bad faith registration, especially for copyright. Trademark, it is becoming more common to take down a trademark. However, it's still very complicated and it's a long process that it could take even years. So the first company to file the application will have a huge advantage over any other company. As a case that can work as an example, many years ago, more than a decade, someone registered in bad faith the name of Michael Jordan as a trademark, and it took more than a decade for Michael Jordan and the Nike lawyers to recover the ownership of that trademark. So if a huge company like Nike and a famous person like Jordan needed more than a decade to get back his intellectual property right, imagine the situation for a SME. So it is very important to have a clear strategy and to act in advance. And the last principle is the territoriality. This means that any registration done in a specific country, the scope of protection will be within the territory of that country. So if we register in China, we will have protection in China, but not in the EU. And in the opposite way, if we register in the EU, we will have protection here, but not in China. So when we are talking about intellectual property rights and in a global strategy, we have to decide very well in advance what are going to be the countries where we will do a registration. Because in the case of, for example, an innovation patent, if we register in the EU, the patent will be published and novelty will be lost. So later we won't be able to protect in China, for example. So it is important to decide in advance and know exactly what do we want to achieve with our intellectual property rights. But let's start talking about technology transfer. What is a technology transfer? There are several definitions that are more or less complex. I like one that is very, very simple but very practical. Technology transfer is the movement or flow of technological knowledge, data, designs, prototypes, materials, inventions, software, and or trade secrets. This is any technology that goes from one party to another one. What is exactly, what are we talking about? What is being transferred exactly? Basically, we are transferring knowledge. We could say, in general, what we are transferring is knowledge, any kind of knowledge. But when we are making a contract, what we are actually transferring are intellectual property rights. We are transferring registered intellectual property rights. For example, a patent, for example, even a trademark can be considered technology transfer. And we are identifying them in the contract we are signing. But also we should know that we will transfer unregistered intellectual property rights like trade secrets and know-how. There are different ways to transfer technology, not only with the contract. Even, for example, this webinar itself, it can be considered a technology transfer because I am at least trying to transfer some knowledge from my side to all of you. You are supposedly learning and improving your situation. So when we are talking about technology transfer, we are talking about consulting. This involves the transfer of know-how, it's a trade secret. Graduating students, it's a technology transfer as well. It's the transfer of knowledge from a university to a company, or from the university to the society, to government. But we're talking about SMEs and companies. We have to take into consideration the 4 other types of technology transfer. For example, collaborative research, where there are 2 or more parties that are adding knowledge for a common goal, for developing a new technology. Both parties or more parties are adding and transferring technology for a greater good. So this could be seen as a way of a joint venture. We have also the technology transfer via patenting. This is when we register a patent, the patent will be published, and any other company in the entire world will be able to see the technology, and it will be available for them. And when I'm saying it will be available, I'm not saying that it will be for free, except in those countries where the patents will not be registered. So it is a way of technology transferring when we are patenting. Also, when we are licensing, this means a contract where we authorize a third party to use our technology. This is a technology transfer. With service and outreach, when we hire someone to do a technology, to perform a technology for us, in the case of a work made for hire, the technology is created by someone and it's given to us. And finally, and the most common one, at least in the situation of China, is spin-off companies or joint ventures. That is the collaboration with other companies to perform to get certain achievement. For doing this, companies add and transfer technology to the joint venture. Spin-off companies are companies that are separated from the main one for a specific purpose, and normally they are the main company transfer technology to the spin-off. Before to continue, let's talk a bit about the type of technology or how to identify and analyze technologies. Basically, we can classify them into 3 categories. One is emerging technologies, those ones that have huge potential, but they are not settled ready. We are not sure if they will succeed or not. So they are risky and uncertain. Then we have innovative technologies, those who are game-changing, for a technology that is already settled, that we know it will succeed, and we know it will create a huge advantage for an SME. And then we have established technology, those that have a tendency to be overcome by new technologies, that we know what we're talking about, we know it works, but most likely there will be a patent, the life of the patent is going to be near to be over. So why it is important to analyze and distinguish what kind of technologies we are talking about is because when we are negotiating with another company about what technologies every party is adding to, for example, a joint venture, we should be able to distinguish the value of each technology. While innovative technologies are more value, an established one is not so much, and an emerging one, it would be risky. So I'm not saying you shouldn't go for an emerging technology, but you should know that it involves more risk, and okay, decision should be taken. So okay, let's become a little bit more legalese and start talking about what are the rules on the relevant laws in China about technology transfer. There are 2 main laws. As you can see, the foreign investment law came into effect this year, the 1st of January. it is, as you can imagine, it's still a little bit uncertain about the practicality of this law, how it's exactly going to be implemented, because, as I said, it came into effect at the beginning of January, and 15 days later, the COVID situation impacted. So at the IPR Helpdesk, we are still studying what are going to be the exact effects and consequences, but we don't have many study cases for this. We also have the regulations on the administration of the import and export of technology. But both rules, they create new principles that are important to take into account. The first one is the national treatment. This was requested by the EU and the United States for China to comply with, because they considered that this was necessary for complying with all the rules of the TRIPS agreement. So they decided to add it in the foreign investment law. The national treatment means that foreigner companies will be treated as nationals, at least at the entrance level. This is that a foreigner company that is applying for any kind of permission and rules or license in China will be treated as a Chinese company. This means that there will be no discrimination, and there will be equal rights when having access to funds, land supplies, tax exemptions, licenses, etc. However, there is a good exception. This means that preferential treatment will be given to foreign companies importing certain technologies, but we will talk about this later again. What's the important part of this, or what do I meant when I said that this national treatment will be applied at the entrance level? Because when a company is entering China, they have to ask certain permissions before performing businesses, or directly they can start getting a wholly foreign owned enterprise or a joint venture, and then in that situation they will be a Chinese company from the legal point of view. But sometimes in the past it happened that it was difficult for certain companies, or the authorities were reluctant to give certain of authorizations. Now with the national treatment, this should be overcome. But as I said, we still do not have cases to study since the COVID situation made everything kind of difficult. Also, these rules talk about investment protections. This means that companies will be able to remit profit, capital gains, incomes, royalties from IPRs, and compensations. They will be able to remit them out of China. There will be no restriction about what currencies they can use to remit the profits. And in the case of technology transfer, they specifically included the sentence saying that local governments will not be able to require a forced transfer of technology to foreigner companies, because this was the situation before, that small government, for example, a city government, when a foreigner company was there, for getting authorizations, for getting a license, they were requiring the disclosure of technologies, and then these technologies were given to Chinese companies, and they were becoming competitors. So now, according to this law, local governments are not allowed to request this. Of course, the national government won't do it also. So if a company is requested to do that, supposedly can go to a higher authority and present a complaint. But again, we still do not have study cases for this. It's something that is developing. Yes, it is happening now. The investment administration, It is related with the topic we will talk later. The government created catalogs and negative lists about what technologies can be imported and exported. So there is not that any technology is freely available to be imported to China. And finally, the legal liabilities about those. It is also related with the administration, because there are certain restrictions and certain prohibitions that if companies do not respect them, they can be liable. And this means that they can lose their IP rights, or even worse, they can lose the license to perform businesses in China. And also the foreign investment law made huge modifications to the type of companies, making that now there are only two types of companies: the wholly foreign-owned enterprises and joint ventures. Before there were three. There were two different kinds of joint ventures, but now there's only one way. But let's talk about bureaucracy, a beautiful topic. When we talk about bureaucracy, and this is particularly important for those SMEs that are considering doing technology transfer to China, you should all know that there are two catalogs. One is for the catalog for prohibited and restricted technology imports, and one for technology exports. They are basically some catalogs of technologies. They have a description of different types of technologies, and they are prohibited or restricted. This means, or this can be understood with the classification that you can see on the screen, that technologies can be freely importable, or exportable. There are no restrictions at all. The technology can be transferred without any problem. But also they can be restricted. This means that if a company wants to import or export a technology, a permission should be asked to the Chinese government. Only if they authorize this technology transfer, it will be possible to perform it. And also there are certain technologies that are prohibited to be import or export. So no matter what, it won't be possible to perform a technology transfer. In the case of the restricted ones, how to obtain these permissions? Okay, in a technology transfer, there will be always a Chinese part. It could be a Chinese partner, or it could be your own company, your branch in China. If you open a company in China and you have your headquarters here in Europe, from the legal point of view, it will be the technology transfer from an EU company to a Chinese company. So this Chinese party, it doesn't matter if it is you or a third party, should apply for a license and should be submitted to the competent foreign trade department of the State Council. The Department of State Council has several offices, and some of them are connected with the type of technology. For example, if we are talking about a technology related with the plane, there would be an office for aircraft technology. So it's not so easy to know where to go, but it depends on every single case. This application should be defined, should be given or not, granted or not, within 30 working days. And if they do granted the license, then the Chinese party will be authorized to sign this technology transfer contract. When it is signed, it should be submitted again to the same office, to the Chinese government, and they will approve or not the the technology transfer contract. This will be done within 10 working days. Again, this is for restricted technologies, how to get the authorization. For prohibited technologies, there are no possibility at all. The technology that is prohibited to be transferred, to be import or export, there's nothing to do. Generally speaking, we are talking about prohibited technologies. We are talking about technologies related with cybersecurity, military issues. They're very specific, and normally, at least in my experience, SMEs do not work in this kind of in these technology fields. But what is very important for SMEs to know is that these catalogs are not exactly the same. So it can be the case that the technology can be imported to China, but then it cannot be exported out of China. So what happens if a company import the technology to China, make improvements, and then wants to export back to Europe? Well, it won't be possible. So it is important to check both catalogs if what you are trying to achieve when transferring technology is to create a research and development agreement and improve the technology, because you should be able to get it back. Otherwise, the technology will remain in China. As you can imagine, this could be essential depending on what is your business goal. But bureaucracy doesn't finish there, because there are also negative lists and encouraged lists. Negative lists are also a catalog, but in this case is for technologies that are restricted or prohibited of being invested in or to research by foreign companies. This is certain technology areas cannot be researched if a foreign party is involved. Again, here we are talking about very specific technologies, normally related with military aspects, and the ones that involve safety of a nation. But since they're being updated all the time, every time a company is trying to do the performance technology transfer, they should check this negative list as well, especially if they are going to make research and development. Because again, this content do not necessarily match with the import and export catalog. So maybe you would be able to import the technology, but then you are unable to research or to invest in, and you will lose your IPRs. So you import them for basically lose them, or you cannot export. You cannot export those technologies. So okay, well, you won't be able to make research. So again, we have to distinguish three types of foreign investment: the ones that are free to invest, that you can do it without any problem. Then you have the restricted ones, and then you have the prohibited ones. The restricted ones, here you don't have to ask for an authorization of the government. However, you may have certain restrictions about what company types to use for investing in these technologies. Certain technologies can only be invested by foreigners if they do a joint venture. So you cannot have a wholly foreign-owned enterprise and research. The ones that are prohibited will be impossible at all to invest by foreign companies. What's the main concern? What kind of restrictions? I said the most important restrictions are related with the company type. If you have a different company type and you want to invest or research, you will have a grace period for modifying your situation and to comply with all the restrictions. It's not that you immediately will lose your IP rights. But if you don't do it, you will lose your IP rights, and you can even face some of the liabilities that I mentioned before. Then we have the Encourage Industries catalog, that is the exact opposite. Certain technologies the Chinese government wants to be imported by foreigners, so they give advantages and benefits, normally related with tax. The companies receive fundings, or it's easier for them to obtain the licenses. And another important idea, situation, or practical tip for SMEs is to study their partner. We talked about a little bit about this topic in my last presentation, about how to study a Chinese partner, how to know that company is reliable. There are different ways. Normally, I advise to have meetings with them and to know them and to get more information about them. Also, you can be helped by public institutions, for example, embassies and chambers of commerce. That's very useful because they normally know the business, in this case in China. But also there is one website that you can visit that is in Chinese language, but it's easy to translate with, for example, Google Translator. And in our website, we do have a guide about how to look for information and how to interpret every information given. That is the National Enterprise Credit Information Publicity System. It's a public database of Chinese companies, and you can know important data, for example, who is the legal representative. This means that that person is the only one that will be able to sign in the name of the company. You will be able to know the capital of the company, to know the size, what is the business type or scope, because if that company do not perform business in the same type or scope that the technology you are transferring, then most likely that company will be using a subcontractor that is in that business scope. So this could be a red flag. You will be able to know if this company has been sanctioned in the past, for example, for not respecting intellectual property rights or for scams. Also, you will have more information about who are the shareholders and who this company belongs to. So this website is very useful for detecting red flags about your Chinese counterparts, because I think this is one of the main difficulties that SMEs face when trying to enter to a new market. Another tip would be to keep your secrets secret. This means that when you are performing technology transfer, to protect your trade secret, as I said, the requirements are non-public information. This is a secret. Also has a value because it provides a competitive advantage for the company, and it should be kept confidential by its holder. This means that protective measures have to be applied to the trade secret. By protective measures, I'm talking about physical measures. For example, with a seal on the document saying that this information is classified. Technology measures, for example, encrypted communications. Blockchain is trending in China about a method to protect trade secrets. Contractual measures with confidentiality agreements. It's also important to train your personnel about how to identify, recognize, and manage trade secrets in order not to disclose them. For example, when giving a webinar, maybe they are talking about sensible information without realizing that they are actually disclosing, for example, a patent, and then this patent will not have novelty and won't be registrable. Finally, companies should know how to use court injunctions for protecting in the trade secret. But if there is no registration, how do I transfer trade secrets? Well, because trade secrets have a value as long as they are kept in secret, then what a company should do is to keep applying the protective measures. So the most basic one is to have non-disclosure agreements, so every party that have access to the trade secret won't be able to disclose, or otherwise it will be sanctioned. Then companies should try to avoid, if you are transferring technology from a headquarter to a wholly foreign-owned company, then it will be easier. But if you are in a joint venture and there is another company or a Chinese company, then when you are transferring trade secret, you should know that your capacity over the trade secret will be damaged, it will be inferior. It doesn't mean that you lost it, because in trade secrets, the secret requirement, it doesn't necessarily mean that anyone else should know the technology, the secret, but it shouldn't be known by the majority of the players in a certain field. So it is possible to transfer it. However, your position will be diminished if there is a third party. The idea, I think, would be to transfer it to a wholly foreign-owned company. So if your technology transfer is mostly based on trade secrets, then it is not advisable to perform a joint venture. Of course, it depends in any case and in every situation, and it's a business decision, but my advice is to try to keep it yours as much as possible, because in this IP rights there is no registrations, and once it is lost, there's nothing else to do. One mistake can mean everything. How to choose your company type? Well, there are basically, you have two options now, because it was reduced, as I said, by the foreign investment law. The wholly foreign-owned company has as advantages that there is no other party, and no Chinese or any other party. It belongs entirely to you. So you will have full control of the intellectual property rights. The disadvantages is that it is restricted for certain technologies, and that the new foreign investment law set certain rules that companies may not like. For example, they are forced to allocate 10% of the after taxes profit to make a fund for employee welfare. So this means that even though they're able to transfer the profit abroad, they also have certain limitations or certain rules that are not normal, or not normal in Europe. Companies are not used to, so it's something that you should take into consideration. In the case of joint ventures, the advantage is that most of the technologies are available for them, especially if there is a Chinese party. As an advantage, it can be said that a Chinese party can bring certain level of knowledge, particularly if we are talking about the Chinese market itself. They may know, maybe you are giving the technology and they are giving the know-how and the expertise on this huge market. It could be an advantage. But the disadvantage is that you won't have full control of the intellectual property right, since the decision making will not belong to you anymore, at least not entirely. It's not that you won't have a say, but you will have to negotiate, so you lose certain level of control. And also joint ventures, the foreign investment law says that every 5 years, the joint venture agreements will have to be renegotiated. This means every 5 years, you will have to negotiate again with your counterparty what are the terms of the joint venture. And this this can be very unsecure or unstable for sensible technologies. So, and then again, the question is, can I freely choose the company type? The rule is that yes, you can, but the exception are the restricted technologies by the negative list, because as I said, they may impose certain conditions to be able to transfer technology, to invest or research on technologies. What are the most important clauses on a joint venture? First, the nature of the relationship. You should be clear and make clear what is the goal and purpose of the joint venture. If it is the case of research and development, you should include them as one of the goals. Then, okay, you have the company type that is a joint venture. You have to make it clear. You have to make it clear as well who are the shareholders. You should make clear what are the parties' contribution, what is the addition or the investment of every party. It could be IPRs or capital when we are talking about technologies, because sometimes it's difficult for MSMEs to know how a technology value. Then remember the classification that I said before about emerging technologies, established technologies. This should be able for you to know what is going to be the share of each company. The company that gives more will have a bigger share. Company that gives less will have less. Also have to share profits, risk, liability, who will pay taxes, who will pay fees, for example, the fee of a patent. This should be included in the joint venture agreement. Then decision making, how decisions are going to be made, how to control how these decisions are being made, how a company can control what the joint venture is performing, because sometimes for a Europe SME that is involved in a joint venture in China, China is far away, and in a situation of, for example, now the COVID, it may not be possible to travel and check what is actually going on that company. So how to control what's happening, it should be, or it is advisable to include it in the joint venture agreement. And finally, what is, if this joint venture has the purpose of research and development, who is going to be the owner of these improvements? The rule normally is that belongs to the company that created them, so it would be the joint venture, but it could be possible to decide that it will belong to another company. It could be you, your Chinese side, both. It will depend. But what you have to know is that when you are obtaining an improvement in China, and this is performed by your employees, your Chinese employees, that they have to be rewarded if the company wants to keep the IPR ownership. And this reward, it should be reasonable. Otherwise, you can be penalized by even losing the ownership of the IP rights. So also you will have to, in the handbook of employees, you should have rules about the ownership with your own employees. Finally, another precaution that you should take into consideration is that when you are dealing with the Chinese party, the improvements done only by the Chinese side should be compensated if you want to have the ownership of the intellectual property right. This means that if a joint venture, you are adding technologies, but the Chinese party, what is adding is the improvement, how to improve the research itself of the technology, then you won't be able to have the whole ownership of this improvement, except if you pay for it, if you make a compensation. And finally, we will talk about licenses and what are the main clauses about how to license technology to China, that this is one of the most common ways of technology transfer. What to take into account. First, the territory. When you are licensing technology, you should make it clear that it's only for the, in this case, it will be the Chinese territory. For that, it is important, again, to register your intellectual property rights, so you can actually guarantee that you are licensing this specific patents, trademark, or copyright, or whatever you are transferring. The duration of the license, you should make it clear what is the content, what is the specific patent, what are the specific trademark in what classes and in what subclasses. In the case of trade secrets, because they are not registered, how to make them clear. The most important, or my advice would be to set a rule about how trade secrets will be identified in the future. For example, any document that has the seal of confidential should be treated as confidential, or any message, any document that will be sent in a specific platform that is encrypted should be considered as a trade secret and keep it confidential. The same situation with the know-how, that any knowledge that one of your employees gives to another employee should be considered as part of the, for example, manufacture process, and with this should be kept as confidential. So the main idea here is to set a rule about how future trade secrets will be identified, recognized, and the rules about how to manage them. Because if you want to describe every single trade secret, you will be limiting yourself a lot. Another important clause is the royalties, because every company wants to have profits. Then control. If you're licensing, you should have a method to control that your limitations, your rules are being respected. One way could be, for example, that the company will need your approval before selling or exporting, so you can actually check the quality and the quantity of the product. Another rule could be that you can visit the place. Then another important clause is to include damages in case of an infringement, a conflict resolution method. In China, it's very common arbitration and mediation, particularly for foreigner companies that maybe do not have a Chinese employee, so the language barrier is huge. So in big cities like Shanghai, Beijing, it is very common to find international arbitrations jurisdiction that you can have the full procedure in English. Also, a good technique is to design what jurisdiction will be the one where parties can discuss their differences. It's also important to have a clause about the return of documentation and every kind of information or document that was received by the party once this contract is over. And finally, what are the limitations that you can impose to your counterpart? First, the improvement. It is important to know that in China it's not possible to avoid the company to perform improvement on the technology, even if you license it, because there is a rule that you cannot stop science. So every clause that says that the company cannot improve the technology will be null and void. So what you can do is to set rules so for your Chinese counterpart would not be profitable to perform the improvement. So you are not prohibiting it, but you are making it more difficult. One rule or one method could be that if technology is performed, that you will have priority or the exclusivity over them, and you can even start thinking about setting a rule about what would be the royalties, that these royalties shouldn't be more than the cost of producing them. So there are different ways to overcome this prohibition of not allowing a Chinese party to make improvement, because you don't, I mean, if you want to make them, if you actually want them to perform the improvement, then there is no problem. But sometimes you just licensing so they can produce and sell, but you don't want them to become your competitors, and even you don't want them to file a patent that is more innovative than yours, and then you will be, yeah, with even a more dangerous competitor. Sub-licenses, you can make a prohibition that you are licensing the technology, but they cannot give them to anyone else, that you are giving this with the exclusivity, or maybe they request you the exclusivity of the technology, and then this will be a limitation for you. You can set the rule of no competence. This means that the licensee won't be able to compete with you, because it is very common, for example, for a company that has a production, a procedure patent that maybe a non-competitor company from a totally different field can take advantage of it. So as a way of getting more profits, they just license the technology, but then you don't want them to compete with you. So you don't want them to add a new field of their business scope, so you add a no competence rule clause. Sorry. Finally, the reverse engineering. If you are licensing technology, but or a trademark, and you are sending a final product, but you don't want them to perform reverse engineering because there are trade secrets involved in this in the product. For example, it could happen that you are licensing a technology for manufacturing a product, but you are actually sending some parts that were manufactured somewhere else, and these parts, even though they are a part of a final product, they have certain technology on them and they are protected by trade secrets, so you don't want them to learn. So you can include a clause about prohibiting reverse engineering. Of course, this will need a lot of control and supervision, and it's very risky, but yeah, it is a possibility, so I have to mention. Finally, some confidentiality agreements. In China, in Europe, it's normal to have an NDA. In China, normally what we advise is the NNN. This means no use, no disclosure, and no circumvent of the contract. This means no use, that the Chinese counterparty cannot use the technology against you. No disclosure is not to reveal the secret, and non-circumvention is that they are not allowed to overcome the rules and compete against you, not to bypass you and to sell without your consent. And one last tip for those who are licensing technology to several subcontractors and don't want to reveal their trade secret is to use what is called modular production. This means that if you want to use China as your manufacture place, maybe instead of having one contractor, maybe you can have several subcontractors and give them specific tasks and ask them to perform one specific part of your final product. So actually they cannot know how to perform the final product. So this way they won't be able to compete against you, and this is a way to protect your trade secrets. Some takeaway messages, because I overpass the time by a lot of time. For those who wants to perform technology transfer, check the technology import and export catalogs, check the negative list and the foreign investment law, study your partner, protect your trade secrets, choose the company type according to your business plan, but also according to your goal, and to taking into consideration the negative lists, because you may be required later to have certain modifications and even change the company type, to license smartly, to protect the ownership of future improvements, and contact your embassy for assistance. But you can also contact us for any kind of inquiry that you may have. We have this helpline that is free, fast, and confidential, and we normally reply within 3 working days. So anything we can do for you, we are more than happy to help. Let's proceed with the Q&A section. Peter, do we have any question? Peter.
Hello, Matias. Sorry, I was muted. So thank you very much for this presentation, and we have received 2 questions. And I would like to ask everybody in the audience once more to do not hesitate to use the questions tab to send us any questions that you might have. So the first question is intellectual property less protected in areas that are of strategic importance to the Chinese government? How can I prevent my technology to be used in military applications by the Chinese army?
Can you repeat the first part, please?
Yes. Is intellectual property less protected in areas that are of strategic importance to the Chinese government?
Yes, they are less protected. It's what I meant with this negative list and this catalog for import and export. Because for the Chinese government, there are certain specific areas that are considered important for the future and development of the nation. And you can find one of the limitations that I mentioned during the presentation, that maybe you are not allowed to import the technology to China, or maybe you are allowed to import but not export, so the technology will keep in China. But also you have the negative list, then you will see that foreigners cannot invest or research in these specific technologies. Normally, this catalog, if you read what technologies are there, normally are related with military aspects, and it could be some health issues as well. But yeah, normally I would say it's military aspects. And how you can prevent that your technology is going to be used by the militaries in China when you just cannot. If they want to use them, they will do, and yeah, they will use it, and you will not have anything to prevent them from doing it. Sadly, that's the fact. That's the reality.
Thank you, Matias. And the second question is, in Europe, it is assumed that 51% and above ownership of the joint venture gives decision-making control. However, in China, I understand this is not the case, and it requires 80% to 90% ownership to gain decision-making control. Could you maybe comment on this?
Yes, it is very much like this. In general speaking, it's not exactly the percentage. What the main idea here is that it's not possible for a foreigner company to have full control of the decision making. So your Chinese party will have a say, because they are very protective. They are very conservative in this way. And as also you can see that I mentioned that if you perform improvements, you will have to compensate them. So even though the decision making will be done the way that the contract is written, if the rules were made in a certain way that actually the foreign company is able to perform, the foreign party, sorry, is able to overcome the Chinese counterpart, that in the sense of they will take every decision, then this clauses could be considered null, and then you enter into a scenario that you really don't want, that maybe the Chinese counterpart will be able to take all the decisions. So my advice is to create a specific method of decision making that gives the Chinese party a say on everything, even though you at the end of the day you still control and take good decisions, but at least that you respect your Chinese counterpart.
Okay, thank you very much, Matias, for the answer. I think we don't have any more questions. If anybody has a question, then you are welcome in the next 10 seconds to write it down quickly.
Yes, and if later they have any other question, they can send an email to the helpline. So we'll be more than happy to help.
Okay, well, if we don't have any more questions, I would like to thank our two speakers, Ms. Gwen Song and Mr. Matias Zubimendi, for this presentation. And thank you very much all for attending the webinar. The slides will be uploaded. I think we just received a question. No, we actually have not. My bad, sorry. So the slides and the recording of the webinar will be uploaded onto our website, which is, Matias, if you can maybe go to the last slide.
Oh, yes, sorry.
It is there. You're more than welcome to follow us on social media and also on our website. And you will also get a follow-up email with the link to the webinar recording and useful links to our social media accounts and our website. So with this, I would like to thank you very much again, and thank you very much for attending the webinar.
Thank you very much to everyone. Have a nice day.